Welcome, everybody. Thank you so much for coming today. For those of you who don't already know me, my name is Tim Armstrong. I'm the Associate Dean for Faculty and Research here at the College of Law. And on behalf of Dean Hammoudi, the College of Law Faculty and Administration, I'm very pleased to welcome you to the 2024 Robert S. Marks Lecture here at the University of Cincinnati College of Law. Dean Hammoudi really wanted to be here delivering this introduction himself. He sends his very deep regrets that due to some work-related travel commitments, he's out of town for this week and unable to attend. I know that Dean Rebouché appreciates how hard it can be to juggle all of the demands that being a dean places on your schedule. Before we introduce our speaker for today, the Robert S. Marks Lecture was established by Judge Marks to enrich the curriculum of the College of Law by bringing to the law school the scholarship and learning of eminent persons in various fields of law. Judge Marks was a graduate of this college and an outstanding member of the Cincinnati Bar for 51 years. The lecture was endowed in 1989 through the generosity of the Robert S. Marks Testamentary Trustees, and we are very grateful for their support. Our lecturer this year is Rachel Rebouché. Rachel Rebouché is the Dean and Peter J. Liacouras Professor of Law at Temple University School of Law. She is also a faculty fellow at Temple's Center for Public Health Law Research and a leading scholar in family law, public health, and reproductive health law. Prior to her appointment as dean, she served as interim dean for 1 year and was the associate dean for research for 4 years. Dean Rebouché is the author or editor of 7 books, the author of dozens of articles in law reviews and peer-reviewed journals, and a frequent contributor to national publications and media outlets in her areas of expertise. Dean Rebouché received a JD from Harvard Law School, an LLM from Queen's University, Belfast, and a BA from Trinity University. Prior to law school, she worked as a researcher for the Northern Ireland Human Rights Commission and the Human Rights Center at Queen's University, Belfast. After law school, Dean Rebouché clerked for Justice Kate O'Regan on the Constitutional Court of South Africa and practiced law in Washington, D.C., where she served as Associate Director of Adolescent Health Programs at the National Partnership for Women and Families, formerly the Women's Legal Defense Fund, and as a Women's Law and Public Policy Fellow at the National Women's Law Center. Please join me in welcoming Dean Rebouché.
Well, thank you. I am really delighted to be here. I'm honored to deliver the Marks Lecture. I want to thank Tim Armstrong, who has been a wonderful host. I want to thank Tanya Hampton, who helped make this day possible, and Andrea Starr, who was also incredibly helpful in making arrangements for today. So thank you for having me here. Today, I'm going to talk about the legal landscape after Dobbs versus Jackson Women's Health Organization, the case that overturned Roe v. Wade, and Planned Parenthood versus Casey. So I think in my time, I'd like to give you a little bit of context for those of you who aren't as obsessed as I am with the aftermath of the Dobbs decision about what Dobbs did and said, but then pivot to what that legal landscape really looks like and emphasize some of the interstate conflict that has emerged in Dobbs' wake before thinking a little bit about medication abortion and how it's changing abortion services on the ground, some of the challenges to the proliferation of pills and the other efforts that have been used to support them. So that's what I have in store for us today, and I'm hoping to leave plenty of time for questions because there's been a lot going on in this space. You may have read about it in some of the papers. There's a lot happening, just as last Friday showed with a case out of Alabama. So by way of background, Roe v. Wade, decided in 1973, as probably most of us know, the Supreme Court found a constitutional right to abortion before viability using a trimester framework in which State power to regulate and restrict abortion was at its very lowest in the first trimester of pregnancy, and then at its very highest in the third trimester of pregnancy. And in Planned Parenthood versus Casey, a 1992 decision by the Supreme Court, the court had the opportunity to revisit Roe. In fact, many thought that Casey would overturn Roe. Instead, the court fashioned a different test for protecting constitutional rights to abortion, the undue burden test. Many of you are familiar with this as well. And the bottom line from Roe to Casey was for at least the Supreme Court that before viability, states could do a lot to restrict abortion so long as it wasn't an undue burden, but they couldn't ban it. After viability, states could ban it, restrict it, regulate in any number of ways. So when Mississippi passed a law that banned abortion after 15 weeks, the reason it passed the law was to ask the question that the Supreme Court answered in Dobbs: are pre-viability abortion bans per se unconstitutional? In other words, Supreme Court, would you like to rethink Roe v. Wade and Planned Parenthood versus Casey? I think it's worth just noting for a moment that the court could have come to any number of different decisions than what it ultimately issued. It could have struck down the Mississippi law as an undue burden because it was a ban that applied before viability. It could have upheld the Mississippi law using the undue burden test because at the time that the law was passed and the time that the Dobbs decision was handed down, Mississippi only had one abortion provider, and that one abortion provider only provided abortions through 16 weeks of pregnancy. So there was a world in which the court could have said the law stands, and it stands as a matter of not presenting an undue burden on a Mississippi person's right to abortion. That's actually what Chief Justice Roberts would have advocated for and suggested in his concurrence. Or the court could have and did overturn Roe v. Wade and Planned Parenthood versus Casey. A majority of the court writing that Roe was egregiously wrong the day it was decided and egregiously wrong in 2022 at the time of the Dobbs decision. So the holding that we have in Dobbs, given these options, was that the strict scrutiny that characterized Roe, the undue burden test, a kind of heightened scrutiny that characterized Casey, gone. Now the test for abortion regulation in this country is the rational basis test. So as I have described to students, and I am not a constitutional law scholar, but my shorthand way for explaining what the rational basis test is, as others have said, the laugh out loud test. So long as you can show up in court and offer a reason that isn't laugh out loud, then you've got a pretty good shot of the law being upheld on the basis of a legitimate state interest. And just so we're clear, Justice Alito tells us just how strong those state interests are. In concluding the majority opinion, he lists legitimate state interests that include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession and the mitigation of fetal pain, and the prevention of discrimination on the basis of sex, race, or disability. And I spend a moment to read that list to you because the first factor, the first state interest that Justice Alito emphasizes, preservation and protection of life from the earliest stages of pregnancy, is an invitation for states to ban abortion at conception at any state in which the state deems that life might exist. It is a roadmap for recognition of fetal personhood, something that we can talk about in wake of the Alabama Supreme Court's decision to confer rights on embryos. Maybe we can address that a little bit in Q&A. So before we get to this rational basis holding, I think it's interesting to think about very quickly what were the factors that supported overturning Roe and Casey and Dobbs, because I think they're instructive for us in thinking about what is the legal landscape in which we now operate. So if you'll remember, Justice Alito told us that there are 5 reasons to overturn precedent: the nature of the error of the previous case, the quality or lack of quality of the reason of the precedent, the disruptive or potential disruptive effects on other areas of the law, the absence of concrete reliance on the rights announced in the precedent, and the workability of the rules that Roe and Casey imposed on the country. And I'm going to take reliance and workability as a way to think about where we are in terms of potential interstate conflict. So reliance, says Justice Alito, writing for the majority, is not a reliance on an abortion right announced in Roe and Casey is not like other rights. It's not like a contract right. It's not like a property right. It's insufficiently concrete to have people who are pregnant in unplanned ways say that they have now relied for their education, for their employment, on an abortion right in thinking about what comes next after an unplanned pregnancy. And that's something we can also think a little bit more about in Q&A. Because although Justice Alito makes a point to suggest that whether or not abortion restrictions are related to someone's ability to pursue education, employment, pursue equality in public life, that is a question that is entirely empirical that courts cannot answer. That courts cannot stand in judgment of whether or not someone's life is better or worse because they were able to pursue or had denied an abortion. But he does give us some hints about where he thinks reliance has moved. He suggests that although it's an empirical question that courts can't answer, there is a lot of evidence that, in contrast to 1973, pregnancy has changed. So too have our notions of pregnancy discrimination. So he suggests that reliance is one reason, lack of reliance is one reason to overturn Roe and Casey, because we have the Affordable Care Act. We have unpaid medical leave. We have the Pregnancy Non-Discrimination Act, or Pregnancy Discrimination Act. We have essentially a sweet, sweet social safety net that buoys all pregnant people to the surface. And so, that was a joke. But at the heart of this is a different conception of what pregnancy is. And it's at the root of where the dissent and the majority opinion disagree about the nature of the burden of pregnancy or the ability of a pregnancy, even if unplanned, to be a gift. So reliance. Workability. Workability is the idea that Casey and Roe deepen the conflict over abortion in this country, created additional confusion and inconsistent case law, that the undue burden test specifically resulted in different decisions by courts that were not, that couldn't be fit together, and created a conflict, both legal and practical, in ways that overturning Roe suggested might shine some light on common ground, or at least the ability of states to take the temperature of their own electorates and pass policies in response. So here's where I think the workability argument is really interesting. Where are we now? Did overturning Roe and Casey, has it resulted in more workable standards and less conflict and less division? Well, I think it's a little soon to say, but I would submit to you that there is evidence that we are not in a more workable legal landscape today than we were before Dobbs. So what does that legal landscape look like? Over 1/3 of states in the wake of Dobbs have banned abortion, most of them from the earliest moments of pregnancy. At the same time, you have a dozen states that have passed laws or enacted constitutional amendments that seek to protect abortion rights. 17 states have enacted what have been called shield laws that seek to protect in-state providers from out-of-state lawsuits. And I'll describe what those laws do in a moment. And these shield laws, they're not just prophylactic measures. The emerging legal landscape, as I've just suggested, is increasingly punctuated by interstate conflict, particularly as states seek to impose their policy choices as widely as possible, even across state lines. So take, for example, Idaho's abortion trafficking law. This applies to minors, but it penalizes, criminalizes those who help minors return to Idaho, having left to seek an abortion somewhere else where it is legal. The Attorney General of Alabama has suggested very recently that he will pursue conspiracy charges against those in the state who are helping those leave the state to have an abortion that would be illegal in Alabama, but legal elsewhere. The conflict is also interjurisdictional. The federal government, the current federal government, has increasingly taken steps to protect abortion rights, and litigation now seeks to understand whether or not EMTALA, the Emergency Medical Treatment and Labor Act, a federal law, might preempt state interpretations like those in Texas of medical emergencies, and whether or not EMTALA requires abortion care as emergency care under that federal statute. But it's not just abortion law that is experiencing a seismic shift right now. It's also abortion practice. So I want to focus in, because I think that there are so many things that we might discuss. I'd like to focus on the uptake and regulation of medication abortion. This is the subject of research that I'm doing with two fantastic co-authors, David Cohen and Greer Donnelly. And it's the subject of our very subtly titled law review article, Abortion Pills. Guess what it's about? So by way of background, medication abortion is a 2-drug regimen that ends a pregnancy between 10 and 12 weeks of gestation. The growth of virtual clinics, which offer medication abortion through telehealth, that followed a court decision in 2020, which temporarily enjoined a rule that the FDA had attached to the first drug in a medication abortion, mifepristone. And that rule was that patients had to retrieve mifepristone, which is prescribed with misoprostol, the second drug in the 2-drug regimen, had to pick it up at a healthcare facility, typically a clinic where most abortions occur, but a medical office, a hospital, or the like. So just to put that in context, of the 20,000 drugs regulated by the FDA, mifepristone was the only drug that you had to pick up in person, but could take wherever you wanted without provider supervision. You could take it at home. So this federal court, as a pandemic measure to reduce patient-provider contact, and because the evidence seemed exceedingly on the side that this rule did not protect patient health and did not serve patient interest, lifted it, and then the FDA followed suit by permanently lifting the in-person retrieval requirement in December, announcing it would do so in December 2021. And I mention this to you because with the removal of the in-person restriction, mifepristone, along with misoprostol, now can be mailed to patients after a telehealth appointment, after prescription by a certified provider. January 2023, The FDA also announced and finalized plans to allow pharmacies for the first time to seek certification to dispense mifepristone with misoprostol, and a few have started. So in the wake of these changes, virtual clinics have proliferated, right? Virtual clinics are expanding. So you could take, for context, the example of abortion on demand, the first large-scale telehealth for abortion provider that is in the United States. So there's an automated asynchronous intake that's followed by an informed consent process that uses a pre-recorded video. Gestational age is assessed by a home pregnancy test and the date of the first day of the last menstrual period. Abortion on demand prescribes medication abortion up to 10 weeks of pregnancy, and only for people aged 18 or older, so as not to run afoul of a state's parental involvement law. The platform that abortion on demand uses was built with HIPAA and telehealth regulations in mind. If we have time, I'm very happy to talk about the deep dive into telehealth regulations that is at the intersection of medication abortion online and these virtual clinic platforms. The entire process takes between 2 to 3 days, and it is $300 to $400 less expensive than a medication abortion in a brick and mortar clinic. So these have become very popular services for lots of folks. I would be remiss if I didn't mention that, of course, not everyone, many people cannot seek a medication abortion through telehealth. Teleabortion depends on various forms of privilege. Most have to have a smartphone or a stable internet connection or an uncomplicated pregnancy, which we know because of deep US health disparities is more likely the case for wealthier and white people. For another, even with remote care, the need for clinical spaces is not going to disappear if you have a pregnancy past 10 or 12 weeks. If you need an aspiration or surgical abortion, either out of need or preference. Nevertheless, mailed medication abortion, because of its design and based on how it's being implemented, has been a vehicle for delivering this care, these services across state lines, no matter where you live. So outside of, for instance, the abortion on demand example, which operates in 22 states and only in the states in which abortion is legal, and permissive, and there is permission to deliver medication abortion through telehealth. Some states, for instance, haven't banned abortion, but they require different parts of the process be in person, which precludes an entirely virtual experience. You have other groups like Aid Access, which work with US providers and providers outside of the United States to ship pills across the country, no matter where you live, in a state with a ban, in a state without one. And I'll say a little bit more about how that's happening. So I offer that snapshot of what's happening for medication abortion and its delivery to suggest that to underscore the intensity of conflict between those who are seeking to expand avenues of access for abortion pills and those who are seeking to shut them down. And because there's so much happening in this space, I'm just going to focus on a few examples that might facilitate discussion. So Alliance for Hippocratic Medicine sued to remove mifepristone from the market by claiming that it was unlawful for the FDA to approve the drug in the first place 24 years ago in 2000. Judge Kaczmarek, a federal district court judge in Amarillo, agreed. In April 2023, the district court issued a preliminary injunction suspending mifepristone's approval. And then on emergency appeal, the Fifth Circuit stayed the district court's suspension of mifepriston's approval, but affirmed the injunction suspension of all FDA action after 2016, which is a point at which the FDA made a number of changes to the safety restrictions of mifepristone. Before that judgment, that injunction could take effect, the Supreme Court stayed the order until it granted cert, either granted or denied cert, or issued a final opinion if cert was granted. The Supreme Court has granted cert. It'll hear oral arguments in this case March 26th, and we can expect a judgment later this spring or early summer. And what the court is going to review is an August decision on the merits by the Fifth Circuit, which ruled that the plaintiffs were likely to fail would likely fail to timely challenge the 2000 approval, and were probably unable to show injury caused by the 2019 approval of the mifepristone's generic. But at the core of the case is this in-person dispensation. That, to be sure, the court's also going to think about deference to a federal agency. It's going to think about theories of standing and where and how injury occurs. But what the Fifth Circuit did on the merits is to say that the FDA had acted arbitrarily and capriciously when it lifted restrictions on MIFI in 2016, but specifically when it made that change in 2021 to change the in-person pickup requirement. So that sits alongside another development that I want to tell you a little bit about. And that is this litigation's and the Alliance for Hippocratic Medicine's reliance on a nearly 150-year-old federal law, the Comstock Act, which could threaten the legality of mailing abortion pills everywhere in the country. So the act was named after Anthony Comstock, a 19th century anti-vice and obscenity crusader. The law dates back to 1873. It prohibited importation and mailing of information, quote, regarding, quote, how or by what means conception may be prevented and abortion produced. The law underwent a number of changes in 1876. It was updated to clarify that the obscene material covered in the act was non-mailable matter and shall not be conveyed in the mails or delivered from any post office or any letter carrier. Anthony Comstock was himself a postal worker, had been deeply involved in the postal service. And section 1461, relevant to our conversation, declares as non-mailable matter every article or thing designed, adapted, or intended for producing abortion or for any indecent or immoral use, and every article, instrument, substance, drug, medicine, or thing which is advertised or described in a manner calculated to lead another to use or apply it for producing abortion or for any indecent or immoral use. Okay, that's a lot to say. So for the first 40 years, the Comstock Act was applied pretty successfully. I think it's estimated that almost 4,000 people, or maybe closer to 3,500, were convicted under the law. Almost 160 tons of literature destroyed. But public backlash culminated along with several decisions narrowly interpreting the act in the early 1900s, led to the law's disuse. And a series of state and federal court challenges were part of those limitations. So abortion providers and abortion rights organizations, pharmacies, and drug manufacturers really up to this point have ignored Comstock. Congress had repealed the provisions relating to contraceptives. The provisions as applied to information were held in violation of the First Amendment, but the abortion language stayed on the books. And the plain language of the act is so broad that it would cover almost every medical instrument, supply, or drug that could possibly be used for any abortion. So in other words, absent the narrowing construction applied by federal circuit courts, the act could effectively ban all abortion nationwide because almost every pill, instrument, or other item used in an abortion would be covered by a literal application of the act. And this, I think it's worth emphasizing, this would be a nationwide ban in effect that has no exceptions, not for life or health, if applied in ways that have been urged by Judge Kaczmarek, that have been suggested or implied by the Fifth Circuit, and that have been some of the main talking points for people who want to see the act applied in 2024. So penalizing anything mailed complements efforts to target information about medication abortion, as well as manufacturing and distribution chains. Legislators in Texas, for example, have floated the idea of requiring internet providers to block abortion pill websites, though it's unclear how this would work in practice. A related strategy has been to complement, to rival the information provided about virtual clinics with information that thwarts the attempts to order and find pills. There's an increasing call for states to not just penalize providers, but also to seek to penalize those who attempt to self-manage an abortion. States have targeted pregnant people's choices and behaviors through criminal law and other laws in other contexts. But there is, I think, an increasing will to police pills by policing people. And we might expect to see states criminalize out-of-state providers if any part of the medication abortion process happens within a state's border. So think about picking up pills, you consume them in a different place, or you consume mifepristone first, 24 to 48 hours later, you take misoprostol. There's any number of arrangements we can think of where someone is in different points in time in the medication abortion process. That's despite some of these strategies to stop mailed medication abortion, pills continue. A recent Guttmacher study showed that as a national average, the number of abortions now is slightly higher than the year before Dobbs was decided. So let me say that again. The average is higher, not necessarily in Texas or but across the nation, is higher now than before Roe and Casey were overturned. And that's in part because of groups like Aid Access, who estimate that they ship between 7,000 and 10,000 packets of pill a month. So how are they doing that? Well, let me tell you a little bit about the shield laws that I mentioned earlier, and I'll wrap up there. So 17 states and 6 targeting telehealth have passed statutes that seek to protect providers who are providing abortions in the state or under state laws that are legal and those that assist them. So the first thing that shield laws do is they seek to protect in-state providers' licenses and malpractice insurance rates. So if a state tries to impose criminal or civil liability on a healthcare professional providing an abortion to someone from another state, that prosecution or lawsuit could be reported to the provider's licensing board, which typically has broader discretion in governing ethics and standards of conduct. Being named a defendant too many times or being subject to a disciplinary investigation, even if the provider ultimately prevails, could result in licensure suspension, higher malpractice insurance costs, reputational damage. Shield laws prohibit state medical boards and in-state malpractice insurance companies from taking any adverse action against providers who face out-of-state legal consequences for assisting out-of-state abortion patients. So this isn't blanket immunity by no means. Rather, it's intended to be targeted protection equal to out-of-state investigations, disciplinary actions, lawsuits, or prosecutions arising from services performed in compliance with the provider's home state law. The second thing I think worth mentioning about what shield laws do, they attempt to thwart interstate investigations and discovery, so both civil and criminal, of the care provided to patients from other states. So on the criminal side, the Uniform Act to secure the attendance of witnesses from without a state in criminal proceedings just rolls off the tongue. Pithy title. Um, it's a law that every state has enacted a version of, and it has a civil counterpart which accomplishes the same goals for witness summons and the like. Even before witnesses are called, police departments in the criminal context usually work together across state lines via formal and informal cooperation agreements. So states, these 17 states, have exempted abortion providers from the interstate discovery and witness subpoena laws while prohibiting state and local law enforcement agencies from cooperating with other states' investigations. This only applies to abortions that are legal in the provider state, and such an exemption does not protect providers if traveling to another state where abortion is illegal. That state could exert jurisdiction over that provider in its own state lines. And it doesn't exempt a provider if traveling to another state from the judgment entered in that state's courts. Even so, shield laws try to prevent courts and law enforcement agencies in the provider's home state from becoming a cooperating arm of another state's investigation. Third, shield laws exempt providers from the state's extradition requirements so long as the individual, consistent with Article 4 of the Constitution, is not fleeing from justice, covering the provider who never stepped foot in another state. And this has been an interesting inroad into thinking about how shield laws operate, because outside of constitutional requirements, some states' extradition laws permit or obligate the state to extradite accused criminals, even if they have never been in the other state and thus not have fled. So shield laws are, again, exceptions, create exceptions to those requirements. And then finally, and maybe most relevant to our conversation, 6 states are attempting to protect providers who are not only providing care to those traveling to their state, but also to providers mailing medication, abortion pills out of state, even to states that ban abortion. So telehealth policies and a standard of care typically define the location of care as where the patient is, but Massachusetts, New York, California, Colorado, Washington, and Vermont, they have passed shield laws that define the location of abortion care, quote, regardless of patient location. And how some providers have interpreted this language is shifting the location of care from where the patient is. So if you're a patient in Texas, it would Texas licensure, Texas laws, to where the provider is. You can avail of Massachusetts shield law to protect what you're doing, so long as what you're doing is legal conduct under the shield law and per the abortion statutes of the state. So that's really what aid access looks to as it ships pills across the country. And they haven't been tested yet in court, but I'm sure we're going to see that at some point. And these are definitions that create qualification for what is protected reproductive health care. It's not an explicit change in care location per telehealth regulations or other regulations under state law. So, these are the legal battles that are happening now, and I think they are certainly contests that will shape the definition of abortion, potentially changing who is culpable for abortion crimes or inviting intrusions into health or personal privacy. I think what remains are questions of information. who has it, who can use it, and resources, who can travel or has an interstate network. These are clearly concerns that predated Dobbs. They have been foundational to abortion access, and they're all the more interesting and salient now. I think if we continue to live in a country in which the privileged can obtain terminations without fear of punishment, but everyone else is at the mercy of the state, then what has been described as the liberatory potential for abortion pills, that's never going to be realized. Because even as states try to police online activity and personal data, it's seemingly more clear that pills aren't going to be stopped, but they can be pushed underground. They can deepen public health and criminal justice consequences that I think abortion bans have, or some of them have, catalyzed. So I think I'll stop there, if that's okay, and invite some questions.